There's no such mens rea, was there?
Yes, there was not the breakdown and the statutory breakdown of mens rea, but it did require a deliberate act by a person or an entity to obstruct using anything. And under the common law, it was so broad, it could be something as simple as Osage oranges or brush, but it was not just a negligent act. For a criminal indictable, it did require a deliberate act against the free flow of commerce. And so it was not something that just you accidentally did. So there was an equivalent mens rea. I don't believe, if what I'm understanding you're saying, that this particular offense is substantially dissimilar because it has a mens rea. I disagree. I believe that the mens rea of having to have a intentional or reckless or knowing deliberate act to block the thoroughfare, which is different from if a truck just dumps its load. If the person didn't pick up that load, then that's a deliberate choice. And that's the gravamen of what this offense is and why it relates to the common law offense.
Let me ask you about another part of the current statute, and that is the part that appears to, or not just appears, but seems to exempt an actor if they in fact have a legal privilege to obstruct. In other words, for example, if someone had a permit, was any such legal privilege in existence in the common law?
In the common law, it required that the act be done without authority. So,
Well, in other words,
without legal authority.
is the way I understand my brief foray into the common law on this issue. The king was not allowed to give such a privilege or exemption ahead of the act itself. Do you have any information different than that?
I guess I misunderstand your question.
Well, in the current setting, the current statute, the city, the executive, whoever it is, can grant a legal privilege for someone to obstruct a highway, and therefore the statute would not be applicable. You agree with that?
Well, the king could allow whoever he wants to obstruct the highway. But in English common law, an act not warranted by law under the common law of nuisance law, which is a separate, there are two different ways that this is a common law offense. Obstructing a thoroughfare by itself and under the penumbra of nuisance law. So
Well, my understanding is that the king could not grant dispensation or license to obstruct the highway. Do you have some authority to the contrary?
I'm just reading from, where did I lose it? Digest of Criminal Law by Sir J.F. Stephen. And an act not, quote, an act not warranted by law or an omission to discharge a legal duty, which act or omission obstructs or causes inconvenience or damage to the public in the exercise of rights common to all His Majesty's subjects, is a common public nuisance. So under the penumbra of a public nuisance, which is separate from and larger, and the state submits that it is broader than the common law offense of obstructing a highway, that is the derivation of where this particular offense comes from. I think I misunderstood your question, and I don't know the answer whether or not the king could grant to a private citizen the right to obstruct a highway. I don't know that answer, but I interpreted that to mean, could the king obstruct a highway? Sure, that's why they're kings. But I don't know. It's good to be king, is right. So.
All right, please continue.
When you look at all the cases that since Darendal have interpreted what the common law test is, Darendal laid out actually three different tests. They did the character and grade tests from Nugent back in 1927. They did a similar elements test, and they also did the substantially similar elements. So each of those requires just as much interpretation as the pre-Darendahl moral turpitude. And I would submit to you that under District of Columbia versus Colts, the character and grade is more important than whether the elements align perfectly. Because even the Supreme Court in Darendahl recognized that modern statutory offenses are not going to be this exact wording as a common law predecessor. And in the two cases that have found since Darendahl a common law antecedent in Lenoble and it's kind of escaping me right now, the common law antecedent is of the same character and grade. For instance, in Lenoble, when this court found that resisting arrest has a common law antecedent, they found that the description of the conduct as well as the description of the statute was substantially similar. And so I would submit to you, even though Darendahl did tighten or make smaller the right to a jury trial, it did not require an exact matchup. And I believe that if you do look at the matchup for a public nuisance, all the elements are there, including the appropriate mens rea. But the irony of how the right to a jury trial has evolved since the Constitution of Arizona was written, it has practically devolved. And now Sean Mack has to prove that he's entitled to this constitutional right. I do not submit that the court should devolve it any further and make it basically not a right anymore, just something that a person has to scrap for and beg for to get a jury trial and practically prove that their crime is exactly the same as what was laid out in the common law. Common law is not going to have statutory elements. It wasn't made up that way. It was made as the way, well, you know how a judge makes common law. But I would submit that we have stated enough cases, as well as the English common law, which this court has acknowledged in the Lenoble case, would allow this court to look to English common law to find the common law antecedent. Further, I'm going to ask this court if there's any further questions. I will reserve my time for rebuttal.
Thank you, counsel.
Thank you.
May it please the court, I'm Kent Carney. I represent the City of Phoenix Prosecutor's Office, the appellee real party in interest. Also present with me is Anna Kryovan. She's a co-worker, not an attorney, but she's going to help with the complex task of analyzing this very detailed statute. When we were all law students in the first year, we generally took criminal law and torts. And we had our brains full of mush, and the professors tried to teach us elements. And so what did they do on criminal law? In our criminal law class, they said mens rea, actus rea. So with Anna's assistance, if we can look at this complex statute, it's not a particularly long statute. It's not well written. If we can have a person commits obstructing a highway or other public thoroughfare, if having no privilege to do so, such person, alone or with other persons, recklessly interferes with the passage of any highway or public thoroughfare by creating an unreasonable inconvenience or hazard. Our statute was plagiarized from Kentucky. In Kentucky, it's intentional and wanton, and their last phrase of the sentence is written with two double negatives. It's not easy to read, but according to Judge Gerber, it's derived from Kentucky. So if I've got the bullet points, they're also on, I think, page 9 of my brief. It has 4 elements. You have the person must act, so obstruct. That's the act, reas, because you have that active verb. As you point out, without legal privilege, now you can get a permit to protest or parade, and the City of Phoenix finest will even help stop traffic so you can go out into the street and do it. Not so under the common law.
Could there be other legal privileges other than getting a parade pass? Or?
Yes, there's a discussion in Kentucky's adoption of their statute about the First Amendment issue, and there might be a perhaps First Amendment prong that I have not developed because it wasn't raised in the courts below But recklessly interfering is the mens rea, and then it uses an objective standard of, by creating an unreasonable inconvenience or hazard, that would be an unreasonable objective person. Why is this different? And that's what you are required to do, is do a comparison. Why is this different from the generalized nuisance theory? Well, when I'm a landowner and I'm interfering with another landowner's property, there's something I'm doing out of my land that's affecting their enjoyment and use, if it's a private nuisance action. If there's a public nuisance, and I only get this from the restatement of torts because I don't understand nuisance law, it's as big as outdoors. It is a broad umbrella. As counsel aptly said, it's a penumbra kind of thing. It's a disjointed common law thrown together. So if you go to the restatement to try and figure out the elements, good luck. It's about 70 pages of here's a bunch of cases, and you can go ahead and set that down and sit down if you want. Nuisance is so broad that it's difficult to find out what the elements are. But what are the requirements? Well, if it's a private or public nuisance, you must use your land in such a way that you're interfering with X. All the statutes, or excuse me, all the cases cited by the defense, 11 or 12 or so cases, all MAC does is do a Boolean search, block, street, jury, before 1912, before we became a state. You get 11 or 12 cases, you then throw it up and you say, well, it's for Judge Dellis to decide, or it's Judge Martin to decide, or for three of you to come forward and give arguments. It's not our burden. Actually, under Dahl, it is. Dahl tells us that if it's less than 6 months, if it's 30-day jail offense, it's presumptively not jury eligible because it's petty. However, or unless the appellant comes forward and does this difficult analysis, where are the elements? Where are the elements here? At no stage has MAC done that. So MAC has not carried his burden, so it is, the presumption remains. When you look at those 11 or 12 cases, they're disparate facts. We've tried at the three levels to kind of collate them, and we brought them under the nuisance theory, and then we pointed out nuisance is so broad that you can't say, well, anything that was a nuisance under common law involving land can be used in this charge. What's a major component that seems to run through my argument? MAC was not using his land to privately or publicly interfere. MAC has a required mens rea. It's not the same level as Kentucky intentional and wanton, but on nuisance actions, the plaintiff does not have to prove the person acted with malice, intent, any form. It's not even an element. If MAC was a landowner and he was interfering with the city's access to its land, and a nuisance and abatement action would be brought, the plaintiff, the city of Phoenix, would not have to show what MAC was thinking, his mens rea. And that's one of the big distinctions between criminal law and civil law. In civil law, you have to show that the landowner was actually really annoyed, materially annoyed, actual prejudice shown. It's a burden on a nuisance that the state doesn't have, where we just have to say a reasonable objective person would be of inconvenience. You would obviously look to the fact, was traffic blocked or backed up, yada, yada, yada.
Are you suggesting that at common law there were never any criminal prosecutions for obstruction of a public highway?
There were lots of criminal prosecutions. Well, it's certainly at least 11 or 12 of them, but they didn't have to show a mens rea, or at least the cases that were presented to this court, the lower two courts, was any of that shown, that the required levels of proof. Think about it in terms of what the test the Dahl court tried to give us. Is it a little difficult to apply? Yes. It's more difficult when one of the parties that is asserting they have this right to a jury trial does not do their job and does not list the elements of nuisance. Judge Dellis is a bright guy. He doesn't have any legal staff, law clerks. He at minimum should have, here's the bullet points, here's the elements for the modern day statute, and then here's the bullet points, or if he hasn't done a nuisance action recently, a city magistrate, JPs generally don't enter into that world frequently, he should have the elements listed, and he must be shown in all of Mac's cases, it's a landowner somehow obstructing a public thoroughfare. Yeah, the 11 and 12 cases that were presented below, those were all landowners. There was a citation to a statute that if you breach the statute, Osage oranges, that's essentially a tree. It's not sun-kissed oranges rolled onto the street. It's a tree that's virulent. If you do Osage oranges, you Google that, you'll come up with government websites about the eradication program of this. Think of oleanders on steroids. It's a horrible thing to dump on your neighbor's property or on the roadway, particularly in Georgia, agrarian society where those things grow up, they block. They're used to divide property line. So if you think of the invasion of Normandy with tanks, and then they hit the hedgerows, and there's these 20-foot tall trees that were centuries old. Well, Osage orange grows 40 feet tall. It's not just oranges dumped on the street, although some of the other things were alluded to were temporary in measure. In a nuisance action, you cannot bring it for someone firing off a firecracker one time. You have to show a continuous ongoing problem. That's a different element. Now, one can only fathom why someone would not bring that to the attentions of the court, but it's not the court's obligation or the opposing party's obligation to establish it. Under Darendal, the burden of proof is squarely placed on the party. Once the statute is presumptively not that 6 months in jail, in this case, max 30 days in jail, then the burden is on the plaintiff appellant, the defendant appellant, to prove, here's the elements of this statute, here are the elements of the common law that we're going under. That kind of analysis was not done at the trial court. Matter of fact, the trial court pleading was, if you used Word Perfect, it was called super copied. Under Word, it's cut and paste and dropped into the petition. Identical arguments. The only difference on the petition was on the jurisdiction. Here's 8 possible grounds, you pick them. That's not the way appellate courts or trial courts should decide this issue if it's a valuable right. The citation to Colts, Blanton backed off of that. So the validity of Colts is questioned, and we discussed that in one of our pleadings below. I think that's a red herring issue. Basically, Mack did not do his job in that he didn't go through this complex task of listing out the elements of what you're comparing to. What the state would ask is, if you're going to improve this situation for Judge Dellis and the Judge Martins of the world, is look to the derivation of the statute. We have affirmative evidence from Judge Gerber that this statute was taken from Kentucky. 2 points. One is they have a higher mens rea. That's about the only difference. And they can't write as well in Kentucky in that last portion of the sentence. And then the second point, when you look to...
Or would it really mean that we have to look to where Kentucky may have gotten its statute from, and if it came from the common law, then wouldn't we make that determination?
That would be a good idea if you're going to follow all the other cases logic that you follow, stare decisis or legislative intent or historical section. On this statute, under relationship to pre-existing law, so you go to the Kentucky statute and then you go to the section relationship to pre-existing law, it has the legislative history. They said, we're taking this out of disorderly conduct. So they took out that disorderly element, which in Arizona in an earlier case where that was missing, trespassing was not considered a common law element. And then at the very tail end, and then to make it a statutory offense, they added a mens rea, which didn't exist in the common law. And then they did this to separate it from prohibiting willfully obstructing a street, railroad, prohibiting willfully obstructing a road, although these statutes were primarily concerned with property interests. So if you look at the derivation of this statute, this comes from Kentucky, and Kentucky, 3 years earlier, so we adopted it in 77. Ours is 77. 3 years earlier, in 74, which is well after 1912, Kentucky decides we're going to take out the common element, we're going to add a mens rea, and we are not using this nuisance. basis. We're not confusing it. The Kentucky statute also has a discussion of First Amendment prong, which hasn't been litigated below, and to quote Seinfeld, yada, yada, yada.
Okay, counsel, I just want to understand.
Sure.
I understand your argument that you believe Mr. Mack failed in his burden of demonstrating to the court how this does or does not fit within Darendal. And I want to understand that you're arguing that on a comparative basis between this statute and the common law, this statute contains elements that are substantially different than that existed at common law, correct?
Absolutely.
One of those has to do with the mens rea requirement,
Right.
yes? Now, would you comment on the legal privilege component that I was discussing with counsel?
Well, frankly, until you raised it, I really hadn't thought that out. And then when, I don't know if it was you or Judge Portley raised it, can you get permission? Yes, under modern day statute, not modern state, under modern day practice, when someone's going to protest, they can go to the police department and they work with them. They have a task force, and they arrange officers on motorcycles with the white hand gloves to ride ahead of the protesting group. We had a protest a few years back. Thousands of people marched, and in front of on the roadway, the officers would get off their motorcycles, stop people from crossing, allow them to pass. This has happened 7 times since I've lived up here in Phoenix. Only on one occasion were they not getting enough interest, and so the anarchist element of the crowd breached their agreement to walk down the road, and they went into a bank and they threw paper up and everything else. That would be exceeding the legal privilege. When the police officers are out there holding traffic.
And my question
Sure.
to you is whether you know or not is whether under the common law as it existed, whether the executive, the king or otherwise, had the ability in advance to grant that privilege.
I have to think about that. Under the common law, there was 2 courts. There was the king's court and ecclesiastical court. I don't know that the king lacked the authority to issue a prior permit, and I don't know that he didn't have the authority to, through a designee, give a permission. I don't know the answer to that, but part of the problem you're going to have, well, which common law? We've been cited a case, 1812. That common law did not come over to the United States because in 1812 they were burning our White House and we were at war. Our common law first ended in 1776, and then there's the common law that existed in that middle term from 1776 to statehood. And I think that what we're interested in is at 1912, what was the common law, which is difficult to research. I agree with opposing counsel that Darendal doesn't make it easy. What they tried to do was keep it simple by doing an elements test, something that we can all do as relatively first-year law students. It wasn't done here at all. So is Judge Dellis wrong? No. Has the Mac shown any common law derivative? No. What the court has been shown is here's 11 or 12 cases where we've done this Boolean search, but we don't have a case that says at common law, here's the elements, this element matches that element. And that's kind of what the 3 cases that Darendal discusses does do. They do have a pronouncement of here's the elements. Part of the problem is there were common law, like burglary, larceny. When we went to law school, we studied the multi-state, and they said, here's the common law that's been developed, but it's difficult to go and look up what are those elements. For something that was created in 74 and adopted by Arizona in 77, unless you can show those are substantially similar, are comparable, there's got to be analysis and the burden is on the appellant, and he has not carried it, what the state would like is a ruling that says, wait, one, you can consider the derivation of this particular statute. It comes from Kentucky. Kentucky was rejecting the common law elements. Therefore, this is not a common law crime. And two, when a party comes before the court at 3 levels and does not do any analysis test by here's the nuisance elements and going through, then you're not really giving the Judge Dellis's of the world or Judge Martin's. They're in a difficult position because then they have to try and go through all the commentaries and they have to try and figure out through the restatement what the elements of nuisance are. And since nuisance, both public and private, is so broad, almost anything would fit under that if you can find, oh, it's somehow related to a road and the road was interfered with. Well, that's going to be a lot of cases as opposed to a mens rea, objective victim standard as opposed to an actual victim standard, ignore the land use that this is all derived from. That's a major component of the nuisance. I see I'm just about done time-wise. Unless you have anything else, I'm much more effective when I'm silent.
Thank you, counsel.
Thank you.
I'm trying to contain myself because it seems that the courts have been making the constitutional right to a jury trial less and less and less until it disappears and it is no longer right. And the fact that the prosecutor, whose job is to do justice, is arguing that this court should have an identical elements test instead of the same character and grade or substantially similar. What are those tests? They're just higher hurdles. And to say that Mr. Mack has not met his burden, what is that burden? Beyond a reasonable doubt? No one's ever laid out what that burden is, but apparently it gets higher and higher and almost unreachable for anybody who's facing jail time in a criminal offense to have that or to meet that burden. So I would submit we met that burden when we presented cases dating back to 1812 from British common law. We met that burden from 1824 when we presented a case that said obstructing a highway is a common law offense. We met that burden with the Kentucky case from 1834. And each of these cases, sure, they don't lay out elements because common law was not good at it, but they said the deliberate act of obstructing a highway is a common law offense, and it relates to the admittedly broad offense at common law of public nuisance. Counsel confuses, or I think it is confusing, the distinction between a private civil nuisance and a public nuisance that rises to the level of a criminal act that the legislature has said is such a grave character and such a grave act that it rises to the level of a criminal act because it requires a mens rea. It requires a deliberate act. And the Kentucky law, that the Kentucky opinion from 1834 that says erecting a fence to obstruct a highway is a common law indictable criminal offense that is punishable by fines and imprisonment. How much more clear can we get? Yes, I am defensive because here we have met the burden and the courts just keep raising the bar and saying, well, now your burden is beyond a reasonable doubt and it has to be exactly the same elements. Really? Show me a common law crime that has actual stated elements like a statute. That's why statutes were codified, so that we could prove things by elements and have a little more of a mathematical equation. If you meet this plus this plus this, you find this result. Well, if we're going to go to a mathematical equation, let's do that here. Because in a mathematical equation, and a nuisance case, which the state concedes is a very broad area, and public nuisance has been described in many cases, including the Johnson case from the Supreme Court of Arizona, that public nuisance is the superset. And obstructing a highway is a subset. In mathematical terms, that the elements within the subset are engulfed within the superset. So if you want something with mathematical certainty, then anything that was within the bigger set of a nuisance and that contains the same requirements as what court after court and state after state has said prior to 1912, then that is obstructing a highway. So either you're going to do what you're going to do. You're going to find that it's the same character and grade, or somebody's going to say, no, it's not substantially similar elements. And you're going to have to go back there and arm wrestle. Which test is it? If we want to try and save the state money, then no one should get a jury trial. We should just say, our state constitutional framers, they really weren't that worried about the government. They didn't think that people needed a trial of their peers. 6 months jail, that's not very severe. They don't need a jury trial. But our state constitutional framers, before the 14th Amendment was enacted, said, hey, it shall remain inviolate. And they did not define some silly test about character and grade or substantially similar elements. They just said inviolate. And when you see case after case from state after state going back to the common law of Britain that says that obstructing a highway is a common law offense, I don't know what else I can tell you. I don't know what else I can feed you here to say we have met whatever burden you want to throw at us, we have met it. And if you look back at those constitutional framers who are rolling in their grave because people have to prove that they have the right to this constitutional fundamental liberty that should be presumed, let them roll in their grave. You can either tighten Darendal and make it shrink to its invisibility, or you can do what the framers intended and say, there's plenty of case law here. There's plenty of evidence here. And we have met that burden. So I ask you, think about what the framers would do. And they would say, there's your common law. It's all over the place. It's every case. And substantially similar is you do a deliberate act, you obstruct the thoroughway, you impede commerce, and you have violated the law. It doesn't matter whether there's authority or not. And Judge, I would directly ask you, what difference does that make? I would like to know so I can answer that question. And I would submit it doesn't make a difference whether there's legal authority. The common law doesn't require it. And to do a deliberate act without legal authority is also implicit within the statute. Thank you.
Thank you, counsel, for your arguments here this morning. Appreciate that. We'll take this matter under advisement. We'll issue a written decision in due course. With that, we are adjourned.
Nice seeing you again. Sorry. Get some more ground. Sorry.
Let's grab it.